Welcome to the deep dive. If you're trying to get up to speed on a really complex topic, maybe for a big meeting, or
Yeah.
you're just fascinated by how legal systems really work,
Yeah.
then this is exactly where you need to be. Today, we are wrestling with a situation that's surprisingly common in German labor law, but just incredibly complex in how it plays out. It's that moment an employee wins a wrongful dismissal suit and is suddenly looking at a claim for massive back pay.
Right. And on the surface, it sounds like this huge moment of victory for the employee. Total vindication.
It should be.
It should be, but the reality is that the financial compensation they're owed, what the Germans call Annahmeverzug, it's almost never that simple. That back pay depends not just on the employer's illegal act of firing them, but very heavily on what the employee did during all that time they were waiting for the court's decision.
That's it. That's exactly what we're getting into today. We are going deep into this really intricate relationship between the employer being in default and the employees, well, their powerful legal duty to mitigate the financial damage. And we're going to be focusing on a very controversial legal idea, Boswillige's Unterlassen,
Malicious omission.
malicious omission of seeking other work.
Yeah, and this is a really surgical deep dive. We're getting into the fine print where German labor law crashes right into social law. And to do that, our sources are critical here. We're looking at some really foundational decisions from the German Federal Labor Court, the BAG. We've also got regional court rulings, like one from Ally Köln. And what's really important, the official operational directives for Germany's Federal Employment Agency. These are the rule books for the job centers.
And we've got a timeline here, which I find fascinating. We're looking at rulings from the early 90s all the way up to a really critical, almost gold standard decision from the BAG that just came down in February of this year, 2024.
That's right.
So our mission really is to unpack what judges are actually looking for when they try to measure good faith.
It's all about this balance, right, between protecting an employee who is fired illegally and preventing that same employee from kind of gaming the system for a huge financial windfall.
Exactly, because what these sources show, and this is the key takeaway right from the start, is that an employee's actions outside the courtroom, I mean, things that seem almost administrative, like how you talk to the job center, those actions can be the one single factor that completely wipes out a claim for years of back pay.
It's incredible. What strikes me is just how meticulous the German system is in measuring every little bit of that behavior. Okay, so let's unpack this. We should probably start with the foundational concept. So let's begin with that cornerstone concept you mentioned, Annahmeverzug, default of acceptance. We need to be really clear on what this means when someone wins their dismissal case.
Okay, so when we talk about Annahmeverzug, we're really talking about the legal domino effect that happens after a termination, a Kündigung, is found by a court to be legally invalid or unworksome. Right.
The single most important point to get here is this. If the court says the dismissal was invalid, that in the eyes of the law, the employment relationship is treated as if it never ended. It just continued seamlessly the whole time.
So the employer's attempt to terminate the contract was just null and void? Legally, it never happened.
Precisely. The contract was never broken. And because the employer was the one who kicked off this whole thing with a wrongful termination, they are legally considered to be in default. They're in default because they failed to accept the work performance that the employee was, ready and willing to offer throughout the entire lawsuit. That right there is the definition of default of acceptance.
And because the employer is in default, the employee is still entitled to their full salary for that entire time, even though they obviously weren't working.
That's right. That's the main consequence. And this entitlement comes straight from Section 615, Sentence 1 of the German Civil Code, the BGB. And the compensation clock starts ticking automatically as soon as the notice period for the invalid termination would have ended. The case law on this is solid. I mean, you mentioned that Ally Köln case from 1993.
Yeah.
It clearly established that the back pay starts to accrue immediately.
So if a lawsuit takes, say, 2 years to resolve, the employee is potentially looking at 2 full years of salary.
Potentially, yes.
That is a staggering liability for an employer, which I imagine is why this concept of mitigation, the big butt of Annahmeverzug, is so incredibly important.
It's the whole check and balance of the system. It's designed specifically to prevent, economic imbalance and what the law calls unjust enrichment. This is the Schadensminderungspflicht, the duty to mitigate damages.
Okay.
And the law is crystal clear on this. The employee must credit any income they earn from another job during that period against their back pay claim.
That makes perfect sense.
Yeah, and it's written right into the law. It's in Section 615 of the Civil Code. But for dismissal cases specifically, It's governed by Section 11 of the Dismissal Protection Act, the KSEHG.
You mentioned that the 2024 Bagger ruling makes a point of saying that Section 11 KSCHG is the one that applies here, even though the text is almost identical to the BGB. Why is that distinction so important for the court to make?
That's a great question. It's a really sharp legal point. While the rules are basically the same, the BAG is deliberately grounding the principle in the Dismissal Protection Act. By doing that, they're emphasizing that this situation arises from a very specific type of breach, an invalid firing, that violates the special protections of the KSCHG. So it reinforces that this whole financial mess was created by the employer's illegal act under that specific law.
I see. So it strengthens the idea that the employee is protected, but at the same time, it reinforces their obligations under that same protective framework.
Exactly. And that brings us to the real legal minefield. It's not about what the employee did earn from another job. It's about what they could have earned. This is Section 11, number 2 of the KSCHG. The law says the employee also has to deduct what they could have earned, but, and this is the key phrase, maliciously omitted to earn, böswilliges unterlassen.
Maliciously. That seems like an incredibly high bar for an employer to prove in court. I mean, how do you prove malicious intent?
That is the absolute core of the problem, and it's what this entire body of case law is trying to solve. The employer has to prove a negative. They have to prove the employee intentionally acted against their own financial interest by rejecting a perfectly good job offer.
It seems almost impossible.
It's very, very difficult. And the entire legal debate from that 1995 case right up to the 2024 ruling is all about drawing a precise line, a line between an employee exercising their constitutional right to choose their own career and an employee who is intentionally abusing this default period to run up the bill for their former employer. The court's goal, at the end of the day, is to make the employee whole, to pay them the difference for their loss, but not to reward them for being idle.
Okay, so to really get our heads around how courts first started defining this idea of malicious omission, we have to go back in time a bit. That 1995 Lag-Cullen ruling, the one with the truck driver, that's a perfect place to start because it deals with a very specific and I think very telling scenario.
It really is. The employee refused a job offer from the very same company that he was suing.
Right.
This case is famous because it drew a very hard line in the sand when it comes to good faith or Treuepflicht. The facts of the case are pretty straightforward. A truck driver gets dismissed. He immediately files a lawsuit to fight the termination. So far, so standard. But, and this is the critical move, he also files a specific motion called a Weiterbeschäftigungsantrag. He's asking the court to order the company to keep him employed provisionally while the lawsuit is ongoing.
That's a bold move. He's basically saying your termination is illegal and I'm demanding my right to keep working for you right now.
It is. But this is where the court found this profound contradiction in his behavior. The employer, who maybe thought their case was weak, turns around and offers the driver his exact job back. Immediately. They said the offer was valid until the final clarification of the matter.
And what did the employee do?
He refused. He said he had no interest in coming back, and then he refused more offers they made later on, even though he was unemployed the whole time.
Wow. That seems like the very definition of acting in bad faith. What the court called truidriges verhalten.
That's it, in its purest form.
You're demanding that a court force your employer to let you work, but when they voluntarily offer you that exact thing, you say no thanks.
And that's exactly what the Lag-Cullen court focused on. They established this really strong precedent. They said, look, if an employee specifically asks for continued employment through a legal motion, then their later refusal of that very same job offer is, generally speaking, considered a malicious omission of earning capacity.
So by refusing the job, he effectively forfeits his back pay claim for that period.
For the period the offer was on the table, yes. His refusal basically negates the claim. The court is saying that this initial refusal is, on its face, prima facie malicious. It just completely undermines the whole basis of his lawsuit.
Because his actions are directly contradicting his own legal position.
Exactly. You can't legally claim you are ready, willing, and able to perform a service while at the same time rejecting a concrete offer to perform that exact service. The court sees that as you actively preventing the employer from fulfilling their side of the contract. You're undermining the whole principle of mitigation.
But hold on, what if the working relationship was just destroyed? I mean, what if the dismissal was for something really toxic and going back would just be unbearable for him?
That's the key nuance, and the court always has to consider it. The concept of Zumit-Barkite reasonableness.
Right.
The court in Köln acknowledged that, yes, if a dismissal was, say, an extraordinary one based on some severe allegations of misconduct, something that completely shattered trust, then maybe going back to work there would be unzumutbar or unreasonable.
But in this case,
The driver had already shown his hand. By filing that Weiterbeschäftigungsantrag, he himself was telling the court that he believed the working relationship could be reasonably continued.
so his own legal strategy came back to bite him.
Perfectly put. The court used his own legal action as direct evidence that the relationship was still viable in his eyes. He couldn't then turn around and claim it was unbearable.
It's fascinating how the court looks at the employee's entire pattern of behavior.
And it gets even more interesting. The case had another complication: geography. Sometime in late 1994, the driver moved. He moved from Cologne to Bielefeld.
That's not a short commute.
Not at all. And this raised a whole new question for the court. If he moves hundreds of kilometers away, is he still demonstrating a genuine Leistungswilligkeit, a true willingness to perform the original job in Cologne?
I mean, practically speaking, he probably isn't. Does moving away automatically mean you lose your right to back pay?
It doesn't automatically forfeit the right, no. But the court used it as another piece of evidence in the overall picture. It casts serious doubt on his actual willingness and ability to do the job he was claiming wages for. If the commute becomes totally impractical, it suggests that you're no longer really capable of fulfilling your core duties under the original contract.
It signals a change in focus. You're moving on with your life, literally.
Exactly. And that just adds another layer to the court's assessment of whether his omission was malicious.
So, to sum up this 1995 case, malice, in this legal sense, can be shown by a direct contradiction demanding a job in court and then refusing it in reality. And that can be backed up by other actions, like moving far away, that make it seem like you're not really ready to work anymore.
It sets that initial benchmark. The easiest way for an employer to prove malicious omission is when the employee rejects the very job they're fighting to get back.
But that's a rare situation.
Very rare. Most of these disputes are about the employee's efforts to find a job with a different company, a third party. And that brings us to the much more complex modern standard set by the BAG in 2024.
Okay, so let's jump forward almost 30 years. The February 2024 BAG ruling. This one had to create the new gold standard for how you measure an employee's efforts to find work with third parties.
Yeah.
The stakes feel much higher here because the original employer has no control over those job offers.
They're much higher. And this 2024 ruling is so important because it really formalizes the definition of Böswilligkeit beyond that simple scenario of refusing your old job. The court defines it not as some active intent to harm the employer, but as the employee being vorsätzlich untätig.
Knowingly inactive.
Knowingly inactive. It means you're deliberately choosing to remain idle, even though you are fully aware of all the objective circumstances, like the fact that there are reasonable alternative jobs available for you.
So we're talking about a conscious decision to do nothing, a deliberate choice to let that financial liability for the employer just keep growing.
Precisely. And the ruling is very clear that simple negligence isn't enough. Even gross negligence, grob fahrlässig, is not sufficient to meet this standard.
So can you give an example of the difference?
Sure. If an employee misses a great job posting because they just, forgot to check a website on a Tuesday, that's probably negligence. But if that same employee gets 5 suitable job offers sent directly to them from the employment agency every week for 6 months, and they intentionally delete those emails without ever applying, knowing they're good jobs, that starts to look a lot like vorsätzliche Untätigkeit. That's the line the court is trying to draw.
And the court doesn't just look at one single action. The ruling says they have to perform an overall balancing act, a Gesamtabwägung. What kinds of things go into that balancing act?
It's guided by 2 huge principles. The first is the principle of good faith from Section 242 of the Civil Code. The second is the employee's constitutional right to the free choice of profession from Article 12 of the German Basic Law. So the court has to respect that an employee has a right to choose their career. But, and this is the key, that right gets limited during this default period by their duty to minimize the employer's financial burden. And this leads us straight into the most contentious part of the whole thing. Zumutbarkeit. Acceptability or reasonableness.
This is the big one. How does a court decide what kind of alternative job is reasonable for someone to accept, especially if they were, say, a highly paid specialist? Is it all about the money?
And that's a critical point. No, it is not just about a lower paycheck. The bag is very clear that an employee generally have to accept a job with a lower wage or even poorer conditions from a third party.
Really, even if it's a big step down.
Yes, because the logic is that the employee still has the chance to win their lawsuit. If they win, they will get the difference in pay from their original employer later on. So taking a lower paying job doesn't cancel out their full claim. It just reduces the final amount the old employer has to pay. It offsets it.
That makes the incentive very clear. You take the job you can get now and let the court case cover the rest of the gap.
That's the idea.
Yeah.
But Zumut-Barkheit also covers non-financial things. The court will look at whether the new job would expose the employee to, say, unreasonable health and safety risks.
Okay.
Or maybe it requires skills or qualifications the employee just doesn't have. Or like in the 1995 case, it involves an extreme change in commute that makes it impractical. All of that gets weighed.
So the bar for rejecting a job offer is pretty high, but it's not just about money. But let's go back to the financial side. Is there an absolute bottom line, a point where a job offer is so low paying that it's automatically considered unreasonable?
Yes, and this is one of the most concrete and important things to come out of the 2024 ruling. The BAG established a clear, measurable threshold, and it's tied to Unemployment Benefit I, or Arbeitslosengeld I, ALGI. An alternative job offer is automatically considered unzumutbar, unreasonable, if the net income you would get from that job is lower than the ALGI benefit you're entitled to.
That is a critical piece of information. The state's own safety net becomes the legal floor for what's considered a reasonable job offer.
It's the legal baseline. The court says an employee cannot be blamed for choosing the option that is financially better for them. If a job offer would actually make you poorer than just taking unemployment benefits, you are acting completely reasonably by refusing it.
It provides a really clear, objective metric for everyone involved.
It does. But the 2024 ruling also dealt with a worker who tried to argue he was making an effort. He took a very marginal job, a mini job, and earned a little bit of money over 6 months.
And he claimed that was enough.
He did, but the court found it was insufficient mitigation.
Why? He was working, wasn't he?
Yes, but this gets into the quality of the effort, not just the existence of it. The whole basis of his back pay claim is that he was available for full-time work. So if he's capable of full-time work, but he only takes a geringfügige Beschäftigung, a mini job that's capped at a few €100 a month, the court sees that as a token effort, not a good faith one.
So the court thinks he's just doing the bare minimum to look like he's trying, while really trying to maximize the back pay claim.
That's the inference the court is allowed to make. They expect a proactive search for a job that actually matches your claimed work capacity. You just take a mini job and can't show that you are also looking hard for something more substantial. You risk the court saying you are being malicious about the difference, the gap between what you earned and what you could have earned in a proper job.
Now we get to what, for me, is the most dynamic and maybe the most consequential part of this 2024 BAG ruling. It's this revelation that an employee's duties under social law, they're now fundamentally tied to whether they win or lose in labor court. The employee's relationship with the agentur for Arbeit, the job center, is no longer a separate issue.
This is a huge shift in practice. I mean, it's a seismic change. Let's look at the specific facts from that 2024 case with the machine feeder. He gets fired, he signs up for unemployment benefits, ALGI. That's all completely normal. But his big mistake, his fatal error, was what he said to the job center official. He told them explicitly that he did not want them to send him any job offers. And then he went even further. He announced that if they forced him to apply for a job, he would tell the potential new employer about his pending lawsuit and basically sabotage his own application because he absolutely wanted to continue working at his old job.
He essentially told them he planned to weaponize his own lawsuit to make sure he never got hired anywhere else.
He did. And what happened? The agency, logically, stopped sending him job offers for over a year.
Wow.
And that act of active prevention is precisely what the federal labor court latched onto to justify their finding of malicious omission. The core legal principle here is that social law duties, the ones in the Social Code Book 3, SGB the third, they now have teeth in labor court.
So before, if you didn't cooperate with the job center, you might get a penalty from them, like a suspension of your benefits, a spurt set.
Exactly. It was a social law problem. But now the labor court is looking at that same non-cooperation and seeing it as direct evidence of Boswilligkeit.
But why does a labor court judge care if someone is following the rules of the SGB third? They're two different areas of law.
They are, but their goals overlap here. The entire purpose of the job center and the duties in SGB the third is to get an unemployed person back into the workforce as quickly as possible. So if an employee goes through the motions, they formally register, but then they actively prevent the agency from actually doing its job.
They're intentionally stopping the very process that's supposed to find them alternative income.
Precisely. And since the whole point of the mitigation rule is to make sure the employee is looking for that alternative income, this kind of self-sabotage is a direct contradiction of their duty. The VAG said this behavior is highly
Meldum, the duty to register, actually require.
The timelines in Section 38 of the SGB Theater are incredibly strict. You have to personally register as a job seeker at least 3 months before your employment is set to end.
3 months before you're even out of a job.
Yes. If you get less than 3 months' notice, then you have to register within 3 days of finding out your termination date. And this duty is absolute. It doesn't matter if you think the firing was illegal or if you've already hired a lawyer. The law wants the job market mobile. Whitridge's Verhalten behavior that violates the terms of the insurance, and the penalties escalate. A minor failure, like missing an appointment at the job center, a Annahmeverzug, gets you a 1-week suspension of benefits.
Okay, that's not too bad.
But refusing a reasonable job offer or not trying hard enough on your own to find work, those are far more serious. That can lead to a suspension of 3, then 6, then 12 weeks for repeat offenses.
And what's the ultimate penalty?
If you accumulate a total of 21 weeks of suspension time, your entire claim to unemployment benefits can be extinguished completely.
Refuse all offers forever.
That's how the court saw it. His stated intention to sabotage his own applications was the smoking gun. It was clear evidence of intentional conduct designed to prevent a job offer from ever even materializing. And this is where the social law paperwork becomes absolute gold for an employer in court. The job center's internal memos and records confirming the employee's self-sabotage. That is concrete, verifiable proof of a malicious act. It's the kind of evidence employers almost never used to be able to find.
This changes everything. It means
Every employer who is on the hook for your wages.
let's shift gears a bit and get into the procedural side of this. The chess game of who has to prove what in court. When an employer makes this claim of Bezwilligkeit, the initial burden of proof is on them, and that's historically been a huge hurdle.
It's the classic rule, and it's designed to protect the employee. The employer bears the primary burden because their illegal dismissal is what created this whole situation in the first place. So the
To the employee's email or their job search history or their file at the job center.
Exactly. It's a massive challenge. They have to scrape together evidence of job postings from public websites or other sources and argue that this specific employee should have applied for them. That's the Darlegans and Beweislas, the burden of presentation and proof.
But the employee can't just sit there and say nothing, right?
No. This is where the secondary burden comes in. The employee has an obligation to respond truthfully and completely about what their efforts were. They have to be transparent.
The employer finds some kind of definitive proof. But the 2024 bag ruling introduced a mechanism that can just flip that entire balance on its head if an employee is trying to cheat the system. It's called Bedingungsbereitlung. the prevention of a condition. This feels like the real game changer.
It is, absolutely. It's a legal principle that applies when one party intentionally and actively prevents a specific condition from being met. In our context, from the 2024 case, that condition is the possibility of the employee finding alternative work through the help of the job center.
So if the employee sabotages the process,
Right. If the employee does what that machine feeder did, tells the job center he's going to sabotage applications, and effectively stops them from sending any job proposals, the court says he has actively prevented the condition. And when that happens, the burden of proof shifts dramatically.
okay, walk me through that shift. Let me see if I've got this straight. If I actively sabotage my own job search, the court can then turn to me and say, okay, now you have to prove that even if you hadn't sabotaged the process, you still wouldn't have gotten any of those jobs.
That is it in a nutshell. It's a penalty for your bad faith actions. You now have to prove a negative, which is extraordinarily difficult. You intentionally destroyed the evidence, the potential application, the interview, the rejection letter, and now you're held responsible for that void.
And what's the result if the employer successfully points to some concrete job listings and proves the employee sabotaged their own chances? Does the court just throw out the entire back pay claim?
Not necessarily the whole thing. The court uses a clever procedural tool. They can apply Section 287 of the Code of Civil Procedure, which allows for judicial estimation.
Estimation.
Yes. The court doesn't need absolute mathematical certainty. It looks at the available jobs, considers the employee's qualifications, and estimates the likely income the employee would have earned if they had acted in good faith. That estimated amount is then deducted from the back pay claim.
So this gives employers a powerful new way objective impossibility. What happens with Annahmeverzug when the employee is sick? We have that 1991 bag ruling. I mean, how can an employer be in default for not accepting work if the employee is medically incapable of working anyway?
This is a really tricky legal tightrope. On one hand, you're right. If an employee is sick and can't work, their performance is objectively impossible. That's Section 297 of the Civil Code. And the employer's argument is exactly what you'd expect. We couldn't have accepted their work even if we had wanted to.
It seems like a slam dunk defense for the employer.
It seems like it, but the bag ruled most powerfully by filing the dismissal lawsuit in the first place. The court said the employer's default is rooted in their original, unilateral decision to issue and then stick by an invalid termination. That refusal to allow the employee to work came before the illness and continued regardless of the employee's health.
I see. So the employer's fundamental breach of contract, the refusal to honor the employment relationship, is the primary cause of the situation, and it overshadows the employee's temporary inability to work.
That's the core legal finding. The employer can't use a random event like an illness, which had nothing to do with them, as a convenient escape hatch from liability when they were the ones maintaining the illegal state of affairs all along. Their failure to accept the work remains, even if the worker gets sick for a while.
This has been a remarkably deep look at this constant tension in the German system, this what would they be?
Okay, the first one, which is reinforced by 30 years of these court cases, is simple but so often missed. Actively seeking is mandatory and continuous. An employee cannot, under any circumstances, just sit back and wait for the court's judgment to land. The second their termination takes effect, they are under this continuous good faith legal duty to look for and accept reasonable alternative work.
If they don't, the back pay claim will almost certainly be reduced.
It's not a maybe, it's a near certainty. It demands a total change in mindset during litigation. You're not waiting for a paid vacation. You're actively trying to minimize the economic damage caused by your employer's mistake.
Right. And the second insight.
The second one is all about the evidence. The job center is critical and central. That 2024 bag ruling proves that your interactions with the agentor for Arbeta are now a fundamental part of your labor dispute. If you fail to register on time, or if you actively tell them not to send you jobs or announce you're going to sabotage things, that will be seen as definitive proof of a malicious omission. The job center's files are now a primary source of objective evidence.
So you have to comply with every single social law duty, not just to get your unemployment benefits, but to protect your entire labor law claim. Okay, and the third insight.
The third is about that new procedural reality we talked about. It's the power shift via prevention. While the employer still has that high initial burden of proof, this new rule on Bedingungsverreitlung from the 2024 case gives them a powerful tool against a bad faith employee. If the employer can show the employee deliberately torpedoed their own job search, the burden flips. Now the employee has to prove their efforts would have failed anyway.
Which, as you said, is almost impossible.
It dramatically reduces the employee's room for error and forces them to be totally transparent about everything they're doing to find a new job.
So these rulings really confirm that German labor law will protect you from a wrongful dismissal, but it demands you be an active, responsible participant in the labor market while you fight that fight.
Exactly. It's a sophisticated legal system. It's trying to balance an individual's rights with economic reality and this core principle of good faith. The courts are making sure that the financial penalty on the employer is proportional to the employee's genuine effort to get back on their feet.
We have completed our deep dive into this really complex intersection of Annahmeverzug and the very strict standards of boswilliges Unterlassen. The tension between protecting the employee and demanding they mitigate damages is clearly one of the most critical battlegrounds in German labor law.
And, it raises a really important question that lawyers and professionals in this field are going to have to grapple with. Given today's labor market and given this heightened level of judicial scrutiny, especially the power of that new Bedingungsverreitlung rule from the 2024 case, has the duty to mitigate damages become so all-encompassing that the actual practical protection you get from the Annahmeverzug framework is significantly weakened?
That's a great question.
I mean, is the employee now effectively forced to treat their legal case as a secondary priority, and their number one job is an immediate full-force commitment to finding alternative work, even if that distracts from their primary goal of getting reinstated?
A profound challenge for anyone navigating these waters. Thank you so much for guiding us through these critical German court decisions and really showing us where the legal friction is.
It was a pleasure dissecting these standards for you.
And thank you for joining us for the deep dive. We'll see you next time.